This is episode 12 of the Inland Empire Workers' Compensation Lawyer live stream podcast, broadcasting live every Sunday at 3 p.m., discussing a new topic in workers' compensation and employment rights. My name is Attorney Alexander Napolin. I'm here with Attorney George Abuado. Today we're discussing receiving a denial after filing for workers' compensation. So if you're an injured worker and you filed for workers' compensation, you are going to either receive an acceptance or a denial. You need to know what to do if you receive a denial. So you need to listen to this short 10-minute discussion that George and I have put together that's going to help you. Now, this is general information and it's not legal advice. Legal advice is something that you receive after the attorney hears the specific facts and circumstances of your claim. So if you're an injured worker in California and you're looking for legal advice, dial our injury helpline at 844-984-8414. Then you will receive a free and confidential case evaluation. For our listeners, let's discuss, why do insurance adjusters deny claims?
Well, I see denials more often than not, believe it or not, especially with the people that we try to help. They might not have made it in time. They might have filed an application after they were let go because they were scared to do it while they were on the job. There's a lot of different reasons why an adjuster or an insurance company would issue a denial. But the truth is that they try to issue the denial no matter what, because the insurance is there to pay you the least amount of money as possible. So they don't want to pay you any money at all. So they can issue a denial, and then they would have to issue an acceptance later on, is better than accepting it from the beginning. So that denial, if there's any possible way that they can issue one and they can have some sort of reasoning behind it, they will issue a denial. That's my experience. What about you, Alex? Have you experienced the same thing, or do you usually get accepted cases right off the bat?
Well, if an insurance, every case is different.
Right.
So some cases are going to be accepted cases and some cases are going to end up denied. You don't necessarily know what's going to happen. Right. Like you said, the adjusters will often find all kinds of reasons to try to deny the claim.
Right.
So one thing is the same on every claim, is that the adjuster is going to try to deny it.
Right.
Right?
Right.
And the adjuster has some time. How much time does the adjuster have to accept or deny the claim?
Well, from when they get the claim, when they're put on notice, they have 90 days to issue either an acceptance or a denial. Now, those 90 days, they don't have to take the whole 90 days. Sometimes they'll issue one before those 90 days are up. They can't issue a denial after those 90 days because, as you know, Alex, if they take more than 90 days to issue that denial, it is presumed accepted. It's presumed compensable. So in order for them to backtrack that presumption, it's going to take a lot, and usually doesn't happen. It would take something like they uncover evidence that they didn't have or couldn't reasonably get within those 90 days. So they have 90 days to issue either an acceptance or a denial. Within those 90 days, that's called the delay period. So they will issue out a letter that says, you're in your delay period. We think we're going to be issuing a denial or an acceptance by this date. They'll give you the date for those 90 days. But during that delay period, you can still get medical treatment. They're still on the hook for at least $10,000 in medical treatment during that delay period. So that's good to know.
Should they expect something? Is it going to take that full 90 days? Is that normally what happens? Or
So 90 days or 3 months, you shouldn't just be waiting around. What you do in that period is continue to go to your medical treatment. If you have a good attorney, they would have gotten you a doctor to see. You can actually get a doctor through the insurance company. So you can request their medical provider network if they have one. If not, you can provide a 4600 letter. So that's a letter from your attorney saying, we elect this doctor to be our primary treating physician. To answer your question, Alex, during those 90 days, you would be receiving treatment, and you would be talking to your attorney about how to move forward, whether there's a denial or an acceptance. Also, with benefits, we did do a video on benefits before, and during those 90 days, if the insurance company is not issuing benefits out to you, then definitely you want to apply with EDD if you have a certification from any doctor that's saying you can't work at that time.
So you're injured, it's probably going to be less than 90 days, and they're potentially going to deny it sooner than that.
Correct. They have up to 90 days. They usually do it sooner than that.
So is it possible that an injured worker could just be receiving medical care and not hearing anything about whether or not their claim's accepted or denied, and it could be like 3 months later before they find out?
So it's not a quick turnaround on workers' compensation issues. So although it might not take the full 90 days, those 90 days, we do need to wait to receive either an acceptance or denial. Or once again, if they don't issue one within those 90 days, it's presumed accepted, and then we move forward. Now, if it's denied, there's different ways to go about it. But when it's denied, I automatically like to request a PQME. As you know, there's different ways you can request a PQME. You can object to a doctor's report, a primary treating physician's report for several reasons, or you can wait for that denial. As soon as the denial is issued, you can request a panel to pretty much get input from the neutral doctor as to the issues that we're fighting. So whether it's causation, did you get injured on the job, whether it's permanent disability, those issues will be taken care of by a neutral doctor. Once we receive that report, we might be able to overturn that denial. How do you handle cases that are denied, Alex? As soon as the denial comes in, what do you do?
If it were me and I receive a denial, it depends on what the denial is for. If it's denied, like there's no factual basis for the claim, then your lawyer is going to want to probably request a priority hearing, a priority conference to receive a trial on AOE, COE, whether or not it factually happened. But if it's some other denial based upon, you don't have enough medical evidence then of course, if the employee doesn't have the medical evidence to establish their injury, and that's why the adjuster is denying it, that's the QME process. And that's what we're going to discuss in episode 13, which is on qualified medical evaluators. So you've received a denial in the mail. You may have also received information on the qualified medical evaluator. And we're going to put out a video next week live, 3 p.m. You'll be able to access that video by going ahead and on our channel. So that's what I would do. If I would evaluate the claim, I would try to determine what the next step would be. And that's why you really need an attorney, is because you don't know what to do next if you receive a denial. The client doesn't know, or the injured worker doesn't know.
I did want to point out, Alex, that we did say a little bit about this in the beginning, but the denial, it's not only possible that your claim is going to get denied, even if you did get injured at work, but in my experience, more often than not, it's probable. So, I try to explain this to my clients whenever I meet with them, but inevitably a client's going to send me a message through our messaging system or an email, or want to have a meeting because, hey, I received a denial in the mail. And they don't understand that does mean something. Of course it means something, but it doesn't mean what they think it means. It doesn't mean that the claim was denied by the court, or there's no way to move forward, or we're out of options. That denial is basically the beginning of your claim. That's the beginning. That's why you came to us, because if you didn't have a competent attorney, an experienced attorney by your side, that denial, you wouldn't understand and say, oh, well, it's denied. I guess I can't do anything about that. But that's not the case. That's far from it. And we're here to tell you that the denial happens more often than you think, more often than not, and is basically just the start of your claim. We are well versed in handling denials. They don't really scare me, to be honest with you, Alex. And when I'm talking to a defense attorney about a settlement and they say, well, this is a denied claim, that carries no weight with me. Like, I don't care if it's denied or not. This person worked 15, 20 years at this job. You don't think if we go to a QME, they're going to find that they have some type of cumulative trauma? I don't care about a denial, So when you get a denial, please don't panic. Make sure you have a good, experienced lawyer on your side. Talk to them about it, or don't talk to them about it, because they're going to take care of it anyway.
Right.
So the important thing for you to understand is it's not as big of an issue as you might think.
That sums up our short discussion on denials of workers' compensation claims and why they happen and what you should do about them. It's general information. It's not legal advice. If you're an injured worker and you need legal advice, give us a call. Dial the injury helpline at 844-984-8414. Tune in next week to episode 13 for a discussion about qualified medical evaluations. If you're an injured worker, your claim's been accepted or denied, you're going to have the opportunity to request a qualified medical evaluation. You should receive paperwork in the mail from the adjuster about this. So if you're an injured worker, tune in.